Hey folks, good morning. I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal litigation to enforce the USCIS Form I-864. Federal litigation and litigation general takes a long time. We're talking months, sometimes even years before you get from filing a lawsuit to a final judgment. And time is not necessarily a luxury that my clients have. If you have a lawsuit under the affidavit of support, that means by definition that your income is very low. Most of my clients are unemployed or working very limited hours, and their whole lawsuit depends on the fact that their income is under the poverty guideline. So these are folks in really pretty desperate situations. If you're in that situation, you can't necessarily wait months or again years to see what happens with your lawsuit and get that reduced to a judgment that you can then enforce. You need help now. So what can you do? In the federal litigation process, there is something called a preliminary injunction. This is basically a way to get into court fast, early in the litigation process, to demonstrate two things. Effectively, that you have a strong chance of winning your overall case, and that you are facing what's called irreparable harm, which is to say that you, the plaintiff, are in a situation that will not be remedied by getting a monetary judgment down the line. Meaning, it's not good enough in the situation that you're in to later get a court to order you judgment down the line that you can collect. What you need is help now. This is called, again, a preliminary injunction. And if successful, the court will order the I-864 sponsor to comply with the sponsor's obligation under the affidavit of support while the litigation continues through the process. This is called, the fancy Latin name is pendente lit support, which basically means something while litigation is pending. Federal courts have actually been very receptive to granting preliminary injunctions in affidavit of support cases. And I think the federal judges really understand that these are vulnerable plaintiffs who, again, can't wait months or a year to get support ordered. They need it right now. It's similar to short-term alimony in the divorce process, where family courts understand we can't just wait till the end of the litigation to sort everything out and get people the financial remedy that they ultimately want. We need something in place now because this person needs to meet their bill payments on a monthly basis, and they need to put food on the table every week. So what we have seen is that courts consistently have granted preliminary injunctions in federal litigation to enforce the affidavit of support. There is no published case anywhere in the United States where a federal court assessed a preliminary injunction motion on its merits in one of these cases and denied it. So that's a good track record for affidavit of support plaintiffs. What goes into a preliminary injunction motion in one of these matters? I'm working on one this morning. So again, the basic components, it's usually a 4-part test depending on your jurisdiction, but what it boils down to is that you are basically presenting a compressed version of your overall case. So we need to demonstrate that the affidavit of support beneficiary, the green card holder, got her status based on the affidavit of support. This is typically done with the results of a FOIA, Freedom of Information Act request. Sometimes we will have the file from a previous attorney if the person was represented. But we will present in either event the signed affidavit of support and the other immigration documents that show how this person made it through the immigration process and got residency based on the affidavit of support. The other primary component of the injunction motion, from a factual basis, is showing our client's financial need. So this will be done with income records, financial statements, bank account statements, showing that our client is either unemployed or working a very limited amount, and that she's under 125% of the federal poverty guideline, which is, again, the whole basis for the lawsuit. Having done that, that's basically a compressed version of the overall case. Irreparable harm, that requirement that I mentioned earlier, it is our position that we show irreparable harm. We show that the person is being harmed in a way that can't be cured by a monetary judgment down the line. She is suffering irreparable harm by virtue of the fact that she's living under the poverty guideline. That is, in our argument, irreparable harm per se, meaning we don't need to show more. All we need to show is that our client is stuck living under the poverty guideline because of the defendant's breach of contract, and that by itself is enough to merit injunctive relief. And courts have been receptive to that. We will often also have even further factors that demonstrate the hardship that our client is in. So we have had clients with special needs children who weren't able to get the special assistance they needed because of the financial situation the sponsor left them in. That would be an extra factor showing hardship. But again, we think that merely by virtue of somebody living in poverty, that is irreparable harm per se, and that merits a court awarding injunctive relief. Now, I don't want to make it sound that injunctive relief happens in a matter of hours or days. This is still a deliberate process that involves an extensive motion packet put together on the part of the plaintiff. The defendant gets an opportunity to respond. The court, if it wants to, can order oral arguments or an evidentiary hearing, and will do that in some cases. So we are still talking about a process that can easily take more than a month. But by the standards of comparing that to the overall litigation as a whole, this is still something that moves much more rapidly through the process than just waiting for the overall case to be resolved. Also, given the strong track record of getting injunctive relief in these cases, we will, of course, especially if the defendant is just asking. What we're talking about here for a household size of one is $1,400 per month. So we will always approach opposing counsel and say, there's no question that the affidavit of support was signed. There's no question that your client owes this obligation. We're talking about $1,400 per month. Before we have a throwdown litigation battle in the early weeks of this litigation over an injunction motion, would you just agree to pay us this pendente lit support? Again, that's agree to pay us the support while the litigation continues. Seems like a smart move to me. Put a little bit of resources towards complying with the affidavit of support, then going to litigation to fighting an injunction motion. Sometimes a defendant will agree to that. Sometimes they won't, but we have courts. If the party won't be reasonable, sometimes all you can do is get them into court to, in this case, an injunction motion, which we will be likely to lose. So again, possibility in these cases, yes, it is a way to get relief much faster, but otherwise be an option. If you have questions of affidavit of support, feel free to drop them into the comments. I'm happy to answer. If you would like an individualized case assessment rights under the affidavit of support, reach out to us on our website. Consultations all across the United States via Zoom. Hope that